Biased Quickie. It's weird that it took until 1961 for the courts to figure out that, in order for the defendant to have the Sixth Amendment right to an impartial jury, they actually need an impartial jury. Hey, we can't expect them to be that smart. They're judges after all. Leslie Irvin was arrested in Evansville, Indiana for multiple homicide, with the police and the prosecutor telling the public falsely that he had failed a lie detector test and had confessed to the crimes, and making several press releases dragging his name through the mud. The press coverage was incredibly hostile towards him. His counsel said that there was no way for him to get a fair trial in Vanderburgh County and moved for a change of venue. The court granted his motion, but just moved it to neighboring Gibson County, which had the same inflammatory press coverage. When his counsel tried again, he was denied because they said there could only be one change of venue. They questioned 430 potential jurors. 268 of them had to be excused for having already concluded his guilt. When they finally did seat a jury, 8 of the 12 jurors admitted they thought Irvin was guilty, but said, "Hey, we can be impartial." What's aggravating is courts still allow that to this day. But if you think he's guilty, by definition, you're not impartial. In January of 1956, he was sentenced to death and subsequently escaped, leaving behind a note affirming his innocence, describing in detail police misconduct, and insisting on his right to appeal. Irvin was recaptured, and the Indiana Supreme Court rejected his appeal, as did the Federal District Court. Irvin appealed to the Supreme Court, who ruled that he wasn't accorded a fair and impartial trial and voided his conviction. They did say that the limitation of only one change of venue wasn't per se a due process violation, but if you change venue to one that has the same issues of impartiality, you haven't solved the issue. Tom C. Clark wrote for the majority, "The right to jury trial guarantees to the criminally accused a fair trial by a panel of impartial, indifferent jurors. The failure to accord an accused a fair hearing violates even the minimal standards of due process. This is true regardless of the heinousness of the crime charged, the apparent guilt of the offender, or the station in life which he occupies. With his life at stake, it is not requiring too much the petitioner be tried in an atmosphere undisturbed by so huge a wave of public passion, and by a jury other than one in which 2/3 of the members admit, before hearing any testimony, to possessing a belief in his guilt." In a concurrence, Felix Frankfurter wrote, "This is, unfortunately, not an isolated case that happened in Evansville, Indiana, nor an atypical miscarriage of justice due to anticipatory trial by newspapers instead of trial in court before a jury." And, sadly, this still somehow continues.